Hello friends, I hope you all are doing well and good. Today I will explain the proceedings under section 482 of CRPC. Now, primarily section 482 under the Code of Criminal Procedure is for the High Courts to exercise its inherent powers. Likewise, for civil proceedings, a provision is entailed under section 151 CPC. However, the only difference between these provisions stands to be that the 482 is inherent power of the High Court and section 151 stands for all the courts, as no specific court is described under this code. The beauty of section 482 stands that Honorable Court not only administers the law but also has the power of acting judicially to meet the ends of the justice. Before starting the reading of this section, many of us who are law students or lawyers who at the early stage of their practice might have heard, or the first thing that comes in their mind is inherent power. As soon as we hear 482, it just pops up into our minds that 482 is inherent power. Now, today I will explain to all the viewers regarding what the inherent power is and what exactly are those powers exercised by the High Court. The inherent power that can be exercised by the High Court lies in the section 482 of the CRPC, my friends. Firstly, the court may pass such orders or as may be necessary to give effect to any order under this code. Like for an instance, if some court has passed some order or some direction which is not implemented, the High Court under this section can very well pass an order for implementation of those orders or directions. Moreover, we sometimes face numerous procedural or substantive lacunae which is not described or not entailed under the statute. In such case, the High Court can very well pass an order in similar matters, my friends. Secondly, to prevent abuse of the process of any court. Now, this power of the High Court is very important and vital power, my friend. This power of the High Court can deal with merely every matters where there is abuse of process of any court, my friends. Thirdly, that the court can very well pass an order to secure the end of the justice. My friends, it is very important to keep in mind that this is a very vast and wide power which is discretionary in nature and it is exercised by the High Courts. Now, I will explain the application of section 482 CRPC with some relevant examples, my friends. Supposedly, if any arbitrary proceeding or any frivolous proceedings are initiated against a person, after being satisfied, court if finds the person wrongly implicated in the case, the High Court straight away will quash the FIR and shall close the proceeding to meet the end of the justice for the person wrongly implicated in a false case. Now, the powers are so vast, my friends, that the High Court can also quash any criminal proceeding even in the cases which are not compoundable. Just for your knowledge, compoundable cases can be withdrawn by the complainant if a compromise has been arrived between the parties, like 138 NIA matter, that is the check bounce case, my friends. I will take you to the case of Sanchit Mohindra and other versus State and another. In this case, my friends, an offence was alleged against the accused under the section of 498A, 377 and 34 of the Indian Penal Code, where after some time the parties arrived at a compromise and subsequently a petition under 482 was filed before the High Court and the court passed an order stating that there will be no useful purpose be served if the parties have already compromised and hence quash the FIR. My friends, even Honorable Mr. Justice Chandradhari Singh, who is a judge of Delhi High Court, while passing an order in the case Raja, Berwa and others versus State and another, which is a 2022 recent judgment, my friends, learned justice opined in that particular case that non-compoundable offences can be quashed in matrimonial disputes if the court is satisfied that the dispute has been amicably settled. Now, again, there are numerous cases where the police makes unreasonable delay in filing the charge sheet and is not arresting the accused, one can approach the High Court and very well pray before the court to give direction to the concerned authority to do their task properly and in a time-bound manner. My friends, I hope you like the video and I request you all to subscribe to my YouTube channel and stay tuned for more videos. Until then, Namaskar, Jai Hind, Jai Bharat.